Cenjene dame in gospodje, spoštovani kolegi, ponovno se oglašam iz Pekinga, Jan Sitar, ekonomski svetovalec, pokrivam tudi Tajsko, Vietnam in Mongolijo iz pekinške pisarne veleposlaništva. Seminar, ki ga bomo slišali danes, je organiziran kot predhodnica poslovne delegacije, verjetno največje do sedaj, ki bo spremljala ministrico za zunanje in evropske zadeve Tanjo Fajon na obisku v Pekingu, Šanghaju in Shenzhenu v sredini aprila. Eden od glavnih ciljev te delegacije je zmanjšati trgovinski deficit na kitajskem trgu, predstaviti kakšne nove slovenske izdelke, podjetja. In kar pa je zelo pomembno, je podjetjem, preden se odpravijo na to pot, na zahtevni in velik trg Kitajske, se je pomembno dobro pripraviti, ker je kar nekaj izzivov in pa tudi priložnosti na kitajskem trgu. O tem smo govorili teden nazaj skupaj z EU SME centrom, ki deluje iz Pekinga. Današnji drugi seminar pa bo predstavil strategijo za zaščito intelektualne lastnine slovenskih podjetij, ter je kar nekaj posebnosti, nekaj pravil na Kitajskem, ki se morda od Evropske unije razlikujejo. Tretji seminar, tik pred delegacijo, pa bo s pomočjo Svetovne banke pripravljen en tak podroben pregled in pa napoved obetov kitajskega gospodarstva, ter pa tudi gospodarstev v vzhodni Aziji in pa regiji Pacifika, tako da si boste lahko še malo bolj makroekonomsko, ne samo mikroekonomsko sliko ustvarili pred vašo potjo na Kitajsko. Današnji seminar organiziramo skupaj s pisarno za mala in srednja podjetja na Kitajskem za zaščito pravic intelektualne lastnine. Zdaj pa bi v bistvu v Sloveniji pa sta naša partnerja Spirit in pa Gospodarska zbornica. Zdaj pa bi rad napovedal prvo govorko, in sicer gospo Heliko Jurgenson, ki je projektni menedžer v China IP SME Helpdesk. Helika, I would like to invite you to take the stage.
Thank you very much, Jan. I would very briefly introduce the China IP SME Helpdesk project. China IP SME Helpdesk is a European Union funded project that focuses on assisting small and medium-sized enterprises from European Union with intellectual property rights related issues when they are internationalizing their business to China. In China, we are covering all the 4 jurisdictions, mainland Hong Kong, Macau, and Taiwan. The project offers a variety of free of charge services. Our core service being the inquiry helpline. You can see the email address here, or via website. You can get in touch with the China IP SME Helpdesk and ask us any question relating to intellectual property rights in China that you might have, and you will receive a reply within 3 working days. Apart from the inquiry helpline, the China IP SME Helpdesk organizes trainings, workshops, and webinars. We organize those together with business support organizations across Europe as well as throughout China. Via inquiry helpline, you are able to book a one-on-one consultation session with our IP business advisor in order if you would like to discuss any of your IP issues in more detail. Through the website, you're able to access a comprehensive library of guides, fact sheets, and other e-learning materials. So the website of China IP SME Helpdesk functions as a one-stop shop for all IP-related materials, information that you need with regards to China and IP. So through the website, you can also access our blog, where you can just see the recent trends in IP. Here is just an example of our fact sheets and guides of how they look like. And if we go to the next slide, China IP SME Helpdesk is a part of a larger family of help desks. You can see the help desks cover India, Southeast Asia, Africa, Europe, and Latin America. All the help desk provides similar services. It is just that the regional coverage is different. And you can see the website address to access the website. And with this, I'll finish my intervention and let's start the webinar itself. Thank you.
Thank you very much, Helika, for this brief introduction in the IP SME Helpdesk. I would invite attorney and business advisor, Ms. Lisa Lu, to take the stage.
Good morning, good afternoon, everyone. My name is Lisa Lu. I am the IP business advisor from China IP SME Helpdesk. As Helika already introduced, we provide the first-line confidential and free intellectual property related services to the small and medium-sized enterprises when they're trying to internationalize to China. And today, I'm going to introduce the IP rights protection in China with the best practices for the small and medium-sized enterprises. And before we go into the presentation, I would love to invite everyone to participate to our quiz. There are only 3 short questions. And by doing this quiz, I can assess how much everyone is aware of the intellectual property knowledge in China. And after the presentation, we will run the same quiz to make sure everyone's take the most important messages. You can also see the improvement you made during this pre and post quiz. Question: when does the trademark and patent protection take effect in China? When you start using the IP, or after the application has been submitted, or once the trademark or patent is registered in China? This is a very important question because this is the this is the foundation of IP protection in China. I'm not going to tell you the answer because you have to go through the presentation and learn it from the presentation. But afterwards, we will have the same quiz and you will see the right answer. I think let's move to the next question. Concerning patent protection, which statement is true? Design patent does not protect the function of the products, or only some types of patent can be registered in China via national and international route. Or if I have patent registered in mainland China, I also have patent rights in Taiwan. Which is true? Okay, let's move to the final question. And which applies to the EU IP system, but not to the China IP system? Industrial design can be protected without registration. Is that only applied to EU, but not in China? Or trademark protection term lasts for 10 years? Or trademark and patent can be registered internationally? Which only applies to EU IP system, but not the China IP system? Okay, thank you for your voting. Now we are going to the details of the presentation today. First, I will introduce the IP protection in China. And following that, we will have a comparison of IP system in Europe and China. And then we will see the recent legal developments, most focusing on trademark and patent law developments. And following that, we will see what IP enforcement in China, what enforcement options you can consider. And lastly, we will discuss the main IP concern and common mistakes SMEs made when they internationalize in China. Let's have an overview of the IP systems in China. As a matter of fact, there's no IP law for a long time until 1979. And actually the first draft of trademark law, which is the first IP law, only started in 1979. And ever since that, the IP system in China greatly developed. China has been a signatory to all major IP treaties, including PCT, the International Patent, and Hague System, the International Industrial Design, and Madrid System, International Trademark, and also Berne Convention copyrights. And ever since 2017, major IP laws has been amended to make the China IP system more in line with the international rules. The IP has been a more and more important role in Chinese economy. And in 2019, China has remained the top origin of PCT international patent. And up until now, it's still the top origin of PCTs. So as you can see, IP is a top national priority, and the government has a plan to make the China as a global IP power by 2035. Now the government is trying to focus more on the quality of the IP, especially for the invention patent. And the awareness of the IP in the Chinese economy is developed as well. Some of the European companies may already realize that nowadays when they negotiate with Chinese partner or distributors, they will often ask how many IP the European companies already have, and are they already registered in China. And let's go to the details of the IP system in China. First, let's see what are the IP types in China. They are very, very similar to EU systems. So there are patents, trademarks, copyright, and also trade secrets. But different from Europe system, there are three types of patents in China: invention patent, utility models, and also industrial designs. Industrial designs also protected as patent in China. For invention patents, it protects the new technical solutions, and also any improvement to a product or process can also fall into invention patents. And for all the patents, there is a principle: absolute novelty applies. That means to be patentable in China, a technology or industrial design must have absolute novelty. That means it must not have been published in anywhere in the world, not only in China, before the date of application. However, there are certain exemptions. For example, if European companies disclose the new technology for the first time in a trade fair recognized by the Chinese government, for example, like CIIE in Shanghai, the European companies can still file the patent application within 6 months without losing the novelty. And for utility models, also absolute novelty principle applies. Different from the invention patents, utility model only protects the functional structural or functional design of the products. So if you want to protect your software, you can't choose utility model to protect it. Invention patent will be the right one. But if your products are physical one, then you can consider to use utility model, also invention patent, to protect it. And for design patent, it's different from the above, the two patents we just talked. Design patent does not protect the function of the products. It only protects the aesthetics aspects of the products. Trademarks is the commonly known IP, not only in Europe, but also in China. For companies' brand name or brand logo, you can always consider registering as trademarks in China. And because we are in the China market and the Chinese are more familiar with Chinese instead of other languages, so consider to come out with a Chinese trademark, Chinese name for your brand before coming to the China market. Otherwise, the Chinese market will come out one with you, and it will be very difficult to control afterwards. And copyright is different from patent and trademarks because there is no compulsory registration system. You can always choose to register copyright in China, but without the registration, you still owe the copyright over your logo, brochures, video, or software. Even though it's voluntary registration, we still recommend you to register copyright because it will be very helpful when you encounter copyright infringement. And the last IP is trade secrets. It's different from patent, trademark, copyright because there's no registration system, no voluntary or compulsory. And how can make some business information into trade secrets? Those information has to satisfy 3 elements. First, it has to be non-public. Second, it has the actual and potential commercial value. Third, make sure you take confidentiality measures to protect those information. Those are the 3 elements of trade secrets. And there is no trade secret law in China. So if there are any trade secret leakages, you should refer to anti-unfair competition law. And there are 3 basic intellectual property principles applies in China. First, registration. That applies to trademark and patent. Without registration, you will not have full protection in China. So if you already file an application in China, that does not mean you have the protection in China. The full protection only take effect when it's granted, when it is registered for trademark and patent. Second principle is that IP is territorial right that applies to everywhere else in the world. That means if you have IP in EU or Slovenia, that doesn't mean the protection extended to China. Check if you already extend your international IP to China, and check if you also apply and grant and register your IP in China. The last principle is first to file principle. It's different from first to use principle. So if you are the first one to apply the trademark or patent, then you can block someone else to file the identical or similar trademark in China. But if you are you are firstly used, but you did not file any trademark or patent, someone else did it, someone else copy your brands and file it in China, then they will owe the copyright, they will owe the rights over those IP, even though you are the first one who used those IP. So those IP principles are very fundamental to understand the IP systems in China. Let's go to more details of the registration system of different types of IP. First is trademark. As I already mentioned, for brand name, logo, and trade name, you can consider registering as trademark. And there are 2 registration systems in China. First is the national one. That means the protection only takes place in China. Second is the international one. That means the protection can extend to China and probably US and Japan and everywhere else, depending on which countries you select. For the first one, national registration system, is that you file a trademark application directly with China National Intellectual Property Administration, CNIPA, that is the China Trademark Office. And the protection only takes place in China. And if you already participate the trade fair recognized by the Chinese government in China, you can file it within 6 months and claiming that the date of you attending the trade fair as the application date. That can help you to extend the protection to even earlier date and to prevent someone else to file a very similar or identical trademarks before you did it. And for the national registration, for the straightforward one, that means there will be no official refusal or someone else there will be no one else to object your application registration. A straightforward registration is around 400 euros, including 40 euros as the official fees, also the autonomous fees. And as you can see, the official fees of the national registration is relatively cheap. But as a European companies, if you want to go to the national registration system, you will have to hire a trademark attorney to do it. That's the Chinese law. And second registration system is international one. That means you file an application and selecting different countries, jurisdictions as the place you want to protect your trademarks. And if you go with the international registrations, you do not need to hire a trademark attorney. And also the language does not need to be in Chinese. However, the official fees is relatively high. It will be more than 700 euros for the international system, which is the Madrid system. So there are pros and cons of both systems, really depending on what's the business plan of the SMEs. And the same as most of the countries in China, the goods and services are divided to 45 classes. The first to the 34th are the classes for goods, and the rest are the classes for services. But different from Europe, there is subclass principle. That means for one class, it will be divided to different subclass. And you will have to check with the IP expert to see which subclass of your goods should be in. If you did not choose all the subclass in one class, that will means you did not get the full protection in that class. So again, check with the IP expert in terms of the subclass. And again, Chinese trademarks are very important. It's not compulsory, but it's highly recommended, especially if you already consider to come to the China market. That will be easier for the customers in China to remember your trademark. And before the registration of trademark, always run a trademark search to see if there is any similar or identical trademark already existing in China. Because there are many Chinese trademarks each year applied with the CNIPA. Only for last year, there are already 7 million trademarks submitted with the CNIPA. So that's a large amount of trademarks. It's very easy to encounter similar marks. If you encounter that, that will means you have to spend more budget to get your trademark registered in China. And to avoid that risk, always conduct a trademark searches beforehand. And for patent, I already introduced there are 3 different types of patent in China. And for the invention patent, the protection terms are 20 years. This is the longest among all those patents. And also because the invention patents will go through substantive examination, that means the official fees will be higher. It's more than 400 euros just for the official fees, and not including the attorney fees. And at least for European companies to get an invention patent granted in China, it will take 3 years. Usually it's 5 years. It's longer because the examination is long. And for utility models, it will only take half a year to get it granted because there's no substantive examination. However, the protection term is shorter. It's only 10 years, and the official fee is also cheaper. It's 64 euros. Design pattern is very similar to utility models in terms of the expense. It's also 64 euros for the examination. And the protection terms last for 15 years. Again, different from utility model and invention patent. Design patent does not protect the function of your technology or your products. It only protects the aesthetic part of the product. Let's have a look of an example to better understand what aspects of the product can be protected by different patents. So for the new method of the augmented reality glasses. If there is new method of displaying virtual information on a view of a real environment, these new methods can be protected as invention patent. And if there's the structure of the glasses can make it easier to take it off or wear it, functional design, that part can be protected as utility models. And for those glasses which has the aesthetic details, which is not a function, it's purely the design, and use the design patterns to protect it. Similar with the trademark, there are also two routes to protect the patent. First is the national route, which means the patent protection only takes place in China. And again, this application will be directly submitted with the CNIPA. The second one is the international one. That means you can file just one application and choosing different places you want to protect your patents. And if different jurisdictions patent office granted, then you will have the protection in different places. For the international one, all of the patents can use the international patents to get the protection. For invention patent and utility model, it will be PCT, and for industrial design, it will be Hague system. Let's have we can read about this case study to understand how different IP types to be used to protect the IP as assets. And also, it's important to protect your IP before coming to China market, especially before attending trade fairs in China. So for these Spanish SMEs, they plan to attend a trade fair in Beijing to showcase their new technology. And this company is in the industrial of agriculture. And they have a new model of tractor, which has new design, new function that allows to lower the fuel consumption because they invent a new engine. However, this new engine, they have not get the invention patent protected in China beforehand. So now they are considering, should they attend the trade fair in China, which means they will have a lot of business opportunities, but also means the loss of novelty of engine. Because if they disclose their engine in the Chinese trade fair, that might mean they cannot protect their engine as patent anymore. And if they do not come to the trade fair because they want to keep the engine as trade secret as long as possible, then it will be a business loss. And maybe some of you already realized that for the absolute novelty requirement, you can always attend the trade fairs in China first, then within 6 months file the patent application. But for this company, 6 months is not enough for them to prepare the patent application. Everything should be in Chinese, and also they are still developing their technology. So how did they attend this trade fair without losing the opportunities of patent protection? You can check this part of the engine. Eventually, they decide to exhibit. They decide to participate at the trade fair, but without the engine. And they conduct the internal legal trainings for the staff who will come to the trade fair to make sure when they discuss with the potential partners, they can discuss the advantage of the new engine, but they do not leak any details of the technology. That's how to maintain the patentability for the engine. And they also notarize the exposure of the tractor to make sure they protect it without being known to the public at the trade fairs. And for the rest of their IP assets, like logo and trade name, they use trademark to protect it. For the product catalog, they use copyright to protect it. For the design of the tractors, there will be design patent. And at the end, they showcase the tractor without losing any of the novelty of the engine. So it's a win-win solution. And later on, they obtain the invention patent for the engine in China because they earn themselves a longer time to prepare the patent application. From this case, we can learn that it's not recommended to participate at a trade fair without prior protection of IP, and use the IP registration and trade secrets to protect technology. The more, if your staff only discuss about the advantage of the new technology, that doesn't mean the loss of the novelty. The absolute novelty principle is really important for patent application. So take it careful. And participation in a trade fair must be planned in advance, and to have all the IP assets ready and protected before coming to the China market. And there is a very brief comparison of IP systems in Europe and China. And this is not all of the difference or comments. This is just a major one. So there are some comments between China and Europe system. First, patent and trademarks can be extended internationally. All of the patents, all the trademark can be filed internationally, not only in Europe, but also in China. And the trademark protection term in Europe and China are both 10 years. The same for invention patent, both protected for 20 years. However, there are differences in terms of IP enforcement. I already explained registration is a very important principle of China IP system, but in Europe, if you do not register certain IP, it's still possible to enforce your rights. But in China, it will be very difficult to enforce your rights in China. And for the classification of goods and services, Europe also applies the international classification of 45 classes. And in China, there is an extra principle, subclass principle. And for industrial design in Europe, you can choose to register it or unregister it. If you choose not to register your design, the protection will only last for 3 years. However, for a registered design, the protection term will last for 25 years. And in China, you have to register your design as design patent, and the protection term lasts for 15 years. For utility models, it's less common in Europe, but widely used in China. For most of the European companies I talked to, utility models still overlooked by those companies. But for Chinese companies, when they build out their strategy, patent strategy, they always consider utility model because it's cheap and also fast to get the patent rights. For customs in Europe, the customs only exempt the imported goods to Europe. But in China, the customs check both imported and exported goods. So we always recommend the companies to use the customs system in China. You can also consult with the IP experts of how to register your IP with the China customs and how to train the customs to make sure they know your IP better, so they can, when they encounter counterfeits, they know they are counterfeits, and they know they should inform the IP rights owner. And we already explained the IP types and also IP principles. And we also know that China has developed a lot in terms of IP laws. For trademark updates last year in January, there is a draft of amendments to trademark law. Noted that this is just a draft. It's not into force. But these drafts can also let us know what's the trend the CNIPA hold in terms of trademark protection in China. So there are two focuses in this draft. First is to reduce the bad faith trademarks. Bad faith trademarks is a very common issue I witness a lot when European companies, they are trying to register trademarks in China. Before they come to the China market or before they register marks in China, they realize their trademarks already get registered by some other Chinese company. And those companies, Chinese companies, most of the time, they know these European marks, but still register it. That is bad faith trademarks registration. For this, and the other focus of this draft is to pose the obligation of trademark use, not only for the Chinese trademark owner, but also for the non-Chinese trademark owner. So to fight against the bad faith trademarks, the draft set of 5 for bad faith trademark registration up to 50,000 RMB for the bad faith trademark registration, and also the court can order the civil compensation in terms of the bad faith trademark registration. And it also forbids repeated trademark application, because for a lot of bad faith trademarks, the register does not have the purpose to use the trademark in a proper business way. And to emphasize the use of the trademarks, the European SMEs should also pay attention to that, because the CNIPA may forbid repeated trademark in the future, and the European SME may only can register 1 trademarks on the identical goods or services in China in the future. Still, this is not in the practice yet. It's just what we learned from the draft. It's also possible that the CNIPA will check the evidence of use of trademarks every 5 years in the future. So for the European companies, if that articles become real, we also recommend you to safely check and preserve the use evidence in China every 5 years. That will require you to consult with the IP experts in China. There is some good news in the draft for the SMEs, especially for the SMEs who are active in the e-commerce platform in China. So it is more clear that the trademark infringement at the e-commerce platform includes using a mark that is identical or similar to the registered mark on the platforms without the right holder's permission. So in the future, if the SMEs found any similar marks on the similar goods and on the e-commerce platform without the consent, it could be the trademark infringement, and it's possible for the European companies to enforce their rights at the e-commerce platform. And for patent, the updates are bigger than the trademarks. So the new patent law actually was published in 2021, and the patent law introduced a lot of new systems. And 3 years later, these years, the details of how to implement the patent laws were also published, including the implementing regulation of patent law and also the patent examination guidelines. There are a lot of new systems, and I'm not going to introduce all of them. I will just introduce the design patents and the inventor remuneration, which are more relevant to SMEs compliance when they consider to come into the China market. So for design patent, the international design has been available in China since 2022. This is a very new industry. This is really new to update, and for now, I have not heard many SMEs use this international design yet. But I'm sure in the future there will be more and more SMEs using international design system, because it has a lot of advantage, including you can just file 1 international application in 1 language, including English, French, Spanish, to register in more than 90 countries. And the company can just pay 1 set of fees in a single currency. That will save a lot of complication. And the company can also renew and manage the registration directly through World Intellectual Property Organization, WIPO. And the other update of design patent is the design patent has been extended from 10 years protection to 15 years protection, in line with the international design. And also partial designs are available. That's a very important change for the creative industry, because if a company decide an app which could run on a smartphone or tablet or personal computer, in the past for this graphic user interface GUI, the company has to apply different applications just to protect those GUI in different devices. But because now partial designs are available, that means to protect GUI, you can only file one application, including different devices in one application. That will save a lot of budget for the SMEs. And the second important update from the patent system is inventor remuneration. That it's important for the European companies if you have Chinese employee who may contribute to your patent. So based on the new rule, first, the remuneration can include not only cash, but also equity, options, dividends. And second, if there is no agreement between the companies and the employees, the companies should pay the inventor rewards to the employees after the patent is granted. For invention patent, it's 4,000 RMB. For design or utility model, it's 1,500 RMB. And this reward has to be paid within 3 months. So if you do not have agreements, if you do not have any provision in your agreements relevant to the inventor remuneration, you should check your agreement and negotiate with your employee. Otherwise, this law will apply. And the second one, it may burden more to the companies. If there's no agreement again, the companies has to pay to the inventor either 50% of the net incomes from the assignment or license of patent, or 5% of business profits for 3 to 5 years as rewards. This is based you cannot find this number in the patent law, but you can find it in the promoting transformation of scientific and technological achievement laws. This is another law, and this could be quite considerable for the company. So to avoid all of these disputes, we will highly recommend the companies to negotiate with the employee inventors and including the provisions in the employee agreement. And we already see how to protect the IP in China. Registration is important. What if after you already register all the IP in China, you still encounter infringement? What enforcement options you can take? And I prepare a roadmap for the companies to better understand what actions they can take. So the infringement in China, there are many forms, including the counterfeits and unauthorized sales, and also trade secrets leakage. When the infringement happens, we always recommend you talking with the IP experts to collect and preserve the evidence, because the evidence collection is quite complicated in China. If you did not do it right, or if you did not prepare the evidence right, your case may fail. For example, if you want to go to the litigation or inform the Chinese authority, they always require the registration certificate in Chinese. If you have international trademarks, that certificate is not automatically in Chinese. You cannot go to the CNIPA's website and just print out a Chinese certificate. That does not help your case, and the court will not accept it. You have to file an application and get the registration certificate in Chinese, chopped with the CNIPA's stamp. That certificate is qualified for the litigation case. And when you collect the evidence, you cannot just screenshot the evidence, because, for example, in the litigation, they will not accept any screenshot evidence. It's not valid evidence. You need to use the notarization or blockchain to preserve the evidence. This step is very important, especially the infringement case becomes very serious. And again, those advice should be given by the experts instead of, should be given by the experts. And after the evidence collection stage, if you found out the counterfeits from the e-commerce platform, you can consider notice the e-commerce platform and ask them to take down the infringing link. I would say all of the e-commerce platform in China, they have this notice and take down system, because based on Chinese law, if they do not collaborate the right owner to take down the infringing link, the platform will have joint liability later on if that is indeed an infringement. So the platforms has very clear procedures of how to notice and how to take down the infringing links. And please contact the platforms. Also, you can consider to inform the administrative authorities to conduct a raid or detain the counterfeits. If you know where is the warehouse, again, it should be the lawyers to contact with the authorities. And these administration actions are relatively fast and cost effective. A lot of companies, European companies, are not aware of these actions, but it's very useful. So if you have any infringements, talk with the IP expert to see if they can contact the police to ask them to help you. And let's have a case study of the notice and takedown procedure on e-commerce platforms. I'm sure there are a lot of SMEs are very curious of how to using this notice and takedown system. And there's a Belgian company in the medical device industry, and they already patented their new product as design patent in China. So they have IP right registered in China. However, they encounter these infringing products on a major Chinese e-commerce platform. And the SMEs contacted the platform immediately and let the platform know, I already have design patent registered in China. Can you please take down those infringing links? But the platform informed the SME that the registration certificate for patent is not enough. You still need to contact the CNIPA and ask them to issue a patent evaluation report. And the SMEs was not aware of that until the platform informed them. And it took the SMEs another 2.5 months to apply the patent evaluation report with the CNIPA and submit and contact the platform again. And eventually the platform accepted the complaints and removed the infringing link very soon. From this case, as all can see, it's important to protect IP, especially for the patent and trademarks registration are very important. And for the companies who are already in the e-commerce platforms, please get familiar with the notice and takedown procedures in different platforms and regularly monitor the platforms. And after for the industrial design patent, it's a little bit different from other IP. After you get it granted, you should ask for the evaluation report as soon as possible to enforce your right. And for a lot of SMEs, when they come to China, there are still some difficulties for the SMEs. For those difficulties, no matter how high the IP awareness the SMEs are, you should still keep this in mind that those difficulties are not easy to avoid. First, the public database in China, it's not that easy to access. The first difficulty is because of the language problem. And the second one is a lot of database, they will require the companies to have a Chinese phone number. And for a lot of European companies who never been to China, it's impossible to have a Chinese phone number. And as I mentioned, bad faith registration is still very common in China. And that bother a lot of SMEs. One of the reasons is because of the first to file principle. Evidence collection is complicated and difficult in terms of to fight against in the infringing link. So always consult with the lawyers how to collect the evidence. Do not just screenshot or take photo of the infringement. That there will not be enough evidence. And the counterfeit issues are always a big trouble for the European companies. And based on the European Commission report, China remains the main country of origin of the majority of fake goods entering the EU in 2022. There are around 74% of the fake goods are from China in that year. For those difficulties, the SMEs cannot avoid, but the SMEs can still do a lot to protect the IP. And to understand IP and to protect your IP in China, we always recommend the SMEs to see what common mistakes are and try the best to avoid them. So at least 10 common mistakes SMEs make when entering the China market. And let's see what the mistakes are. First mistake, I have used my trademark in China, so my trademark is protected in China. This is wrong because of first to file system. That means you have to file your trademarks to block someone else to register it. And after the registration, your trademark can be protected in China. Only using your trademarks will not give you any protection. In other way, if you do not have trademark, but someone else have a trademark right in China, using that trademarks could be an infringement to other people's rights. Second mistake, I have IP registered in EU. That means my IP is protected in China. Remember, IP in EU or Slovenia doesn't mean the IP protection in China. I do not need to, the next mistake, I do not need to register my IP before attending the trade fair in China. Remember, registration can give you the protection. Even though you just attend the trade fair, you do not make the decision to come to the China market, you still need to protect your IP before coming to China. Otherwise, someone else may realize may know your IP during the trade fairs, and then they start copying your brands in China. Next mistake, with international trademark certificate, I can enforce my rights in China. Double check if the certificate is in Chinese. If it's international trademarks, you do not have the Chinese certificate automatically. So you still need to apply one for it. Next mistake, IP registration already costs money. I do not want to spend extra budget for the searches before registration. This is wrong because because trademark searches and the patent freedom to operate are very important. That can help you to identify if you can register your IP, and also if you enforce your IP in China, will it infringe anyone else's IP? So that can also help you to avoid a lot of risk in the future. Next mistake, I have trademark registered in China. The customs will automatically inform me of counterfeits. This is wrong because you have to record your IP with the China customs. Otherwise, the customs will not know your IP. Also, if budget allows, please have your trademark attorney to train the customs to identify which is the real products, which is the counterfeits. Next mistake, the screenshots or photo of infringing online shop counterfeits should be enough to prove the infringement. I mentioned it several times, that will be not enough, especially for the serious infringement. You need to notarize those evidence, otherwise those evidence will be invalid. Next mistake, I have IP registered in mainland China, so I can safely use my IP in Hong Kong, Taiwan, and Macau. Remember, there are different IP systems applied in 4 jurisdictions. So if you have trademark in mainland China, you do not have the same rights in Hong Kong, Taiwan, or Macau. Next mistake, my friend recommends a Chinese company to be my manufacturer in China. I can cooperate with this company. You still need to do the background search, even though your friend recommended to you. Background search are very important. They can help you to identify red flags of this Chinese company. For example, like, are they a decent company? What's their business scope? And are they involved in any litigation? And what's their IP portfolio? This information are very important. And the last common mistake, making my Chinese partner sign an NDA will damage our business relationship. This is really, really incorrect because NDAs are widely accepted in Chinese business. So please don't be shy. Ask your partners to sign an NDA. It's really important to protect your IP, and especially for the trade secret. And as a summary of the presentation, I leave some takeaway messages. First, audit your IP assets and obtain IP protection. For trademark and patent, no registration means no protection in China. And counterfeiting issues and bad faith registration from China are quite common. Keep that in mind and protect your IP beforehand. And e-commerce platforms, please regularly monitor it and use the notice and takedown system. In terms of enforcement in the infringement, please consult a lawyer to collect and preserve the evidence. And because the Chinese law changed greatly, study the laws and regulation involved in your industry. And for any questions, you can always contact us. This is the channel to find us. And as I already said from the beginning, we will run another quiz with the same 3 questions. And this time I will let you know which is the right answer. And also you can see if you already learned the most important messages from today's training. Okay, let's see the first question. I believe you can also see from the screen. When does the trademark and patent protection take effect in China? I assume most of the people already scanned this queue. If not, please join us from using the code. And this time, most of the people choose the correct answer. So yes, the trademark and patent can be protected fully after they are registered in China. It's not when you use the IP, it's not when you submit the application. The protection takes effect after the registration. Next question. Concerning patent protection, which statement is true? Design patent does not protect the function of product. Is it correct? Only some types of patents can be registered in China via national and international routes. If I have patent registered in mainland China, I have patent rights in Taiwan. And yes, all of the participants choose the right one. So for design patent, it does not protect the function. And for the patents protection, if you want to protect in China via the international patent, you can always file international patent in China, including industrial design, invention patent, and utility model. And mainland China is different from Taiwan in terms of IP system. So if you have IP in mainland China, you still need to go through different procedures to protect it in Taiwan, also Hong Kong and Macau. The last question. Which statement applies to the EU IP system, but not to the China IP system? Industrial design can be protected without registration. Trademark protection term lasts for 10 years. Trademark and patent can be registered internationally. Okay, congratulations, everyone chose the right answer this time. So industrial design in China has to be registered to get the protection. And for the rest of the options, I think the participants or the audience know it very well.
Okay, now we will switch to the Q&A session. I see we have several questions from the participants. Albert is a very experienced professional in the field of IP protection. Maybe would you like to say a few words about you and your work?
Thank you for having me, Lisa, Martin, everyone. Thank you for having me. My name is Albert. I'm currently located in Beijing. I'm also the IP expert for the SME Helpdesk. In future, if you guys have any issue having inquiry to the SME Helpdesk, I will be able to assist you guys as well. I've been practicing IP law for the past 20 years. I've been doing IP in both mainland China and Hong Kong as well. And over the past 2 decades, I've been helping a lot of foreigners to come to China, to invest in China, to protect their brands, to enforce their rights in China as well. I guess it's a little bit of my background, and I would like to take any questions from you.
Perfect, thank you. So yeah, we have a few predefined questions, and I will ask them, and then I suggest that we allow, because I see that two participants, one is the company Microbiome, probably it's Gregor, we know each other, and Dragana have several questions, so we will allow them to ask directly. But let's start with the questions. So the first one is, when would you advise a Slovenian SME company to think about registering their IP in China?
Albert, would you like to answer that questions?
Right, let's see. Well, that's a very broad question, isn't it? First of all, what is the IP about? Is it about, is it about patent? Is it about, trademarks? Let's put it this way. Let's assume that they're asking either patent or trademarks. If it's trademarks, I always recommend people, even before they start any business in China, try to register in China as well. To be honest, there are a lot of trademark watchers, especially in China. They will monitor all the new brands from all over the world and try to register it before the right owner comes to China. So China is too big the market to miss, isn't it? So my answer to your question is always, even without any plan to come to China, start to register your trademark in China first. If it has been registered, there are some other ways to remove the obstacles. And over the past 5 years, I've been seeing the trademark office in China very active in removing all the obstacles, all the bad faith registrations. So don't be disappointed yet. If your trademark is being stolen in China, there are always something you can do about it. So this is about trademark, isn't it? And about patent, well, patent is international. You know that if you apply for it in the US, in Europe, you don't get protection until you have your application in China as well. So and if you have been registering your patent in without doing it in China, you will lose your novelty, isn't it? You won't be able to get it in China. So PCT is a good way to start, meaning that when you start your application in your own country, at the same time you designate a few countries and get the protection at the same time. I don't know if I can answer your questions, but well, two aspects, trademarks and patents.
Good, thank you. So the second question is, what are the advantages and disadvantages of registering a trademark via CNIPA, so the Chinese authority, compared to the Madrid system?
Right. It's a question that a lot of people would answer would ask as well. Maybe Lisa can explain more, but in my personal opinion, yes, there are pros and cons. Pros is that IR, international registration, is published not in China, but in the international bulletin, isn't it? It means that a lot of Chinese right owners, they won't notice it at the time when they are being applied for, meaning that the obstacle of being opposed by someone else is lower in registration, I think. But in terms of refusal, sometimes my experience tells me that sometimes China's trademark office has a higher standard in terms of examining international registrations. And also a lot of IR will be refused on the grounds of non-standard and services. China strictly follows these classification and those, these items. If you, especially in the US, if you have very long description of goods or services, a lot of time they are being opposed, refused by the trademark office in international registration. So there are always pros and cons in terms of international and local, but I would suggest that, well, you can still go with the international first. And if there's anything wrong, go to the local one. And there's no problem about founding both applications at the same time.
Perfect.
How about you, Lisa? What do you think?
I can make some points of the pros and cons of CNIPA application, which is the national one, and the Madrid system. For the CNIPA, there's a limitation because the protection only applicable in China. But for the international one, if you choose different jurisdictions, you can just file one application and apply applicable to different countries. But for the CNIPA one, you have to hire a trademark attorney, and the language has to be in Chinese. Everything will be in Chinese. But for the international systems, you can file it not in Chinese, but in English or Spanish and other languages, official languages. But for the CNIPA, yes, the official fee is lower, but you have to consider the attorney fee. For the international one, the official fee is higher, but maybe you can save some attorney fees from applying it. But you are always welcome to consult with me or the IP experts like Albert to see which one is more suitable for you.
Thank you, everybody, for your participation. Thank you, Lisa, Albert, and everybody for your organization participation. So if there is no more questions, we can finish. And I wish you a good day.
Thank you, everyone. And also, I leave an event feedback form here. So I hope people can, the audience today can let me know what questions you have and what type of training you want us to host in the future. And also, how are you feeling about today's presentation? And thank you, everyone, for your time. I hope you learned, and we will keep in contact in the future.